Hi everyone, welcome back. In this session, we are going to discuss about some of the general principles of private international law. And general principles is we are going to discuss about the various stages in a case with foreign element. That is why we are discussing about private international law. So there is a suit, there are various stages in the suit, and this suit is having a foreign element. So when it comes to a suit with foreign element, we have 4 stages. The first one is the determination of jurisdiction or deciding the jurisdiction, and then the second one is classification of the cause of action, and then comes the selection of lex causae, and then comes the application of the lex causae. So jurisdiction is where the court determines whether the court has authority to adjudicate that subject matter, and then comes the classification of cause of action. The classification of cause of action is the process where the particular act or offense is placed in a particular category, and this is important because it is based on this classification that it is ascertained which set of rules or law is to be made applicable in this situation. And then we have selection of the lex causae. Lex causae means the law of the cause. Here, after the cause of action is classified, the further step is to choose the appropriate foreign law or to select the lex causae. So which foreign law is to be applied, that is determined in this stage. And then comes the once the lex causae is determined, then we have application of lex causae, and we have an important doctrine under application of lex causae, that is the doctrine of Renvoi. And we have two kinds of Renvoi, that is simple Renvoi as well as double Renvoi. So what are simple Renvoi and what is double Renvoi, we will discuss in detail. The detail about the jurisdiction, determination of jurisdiction will be dealt in a separate section. Now towards classification of the cause of action. Now the famous case law we have under classification of cause of action is Maltese marriage case. Now why is classification of cause of action important? So the Graveson has remarked that classification is a normal and necessary process of human thought. Now in all systems of law, the various legal rules are arranged under specific categories or divisions, like the contract, tort, succession. So only if we make an appropriate classification, we can find out which law, whether it is the law applicable to contracts or law applicable to tort, which law is to be made applied. So that is the importance of classification of the cause of action. Now Cheshire has defined it as what is meant by classification is the allocation of the question raised by the factual situation before the court to its correct legal category, and its object is to reveal the relevant rule for the choice of law. So it is done by the court based on the factual situation. And why is it done? It is to reveal the relevant rule for the choice of law. So here it can be further understood with an illustration, that here we are discussing about a man X, and this person is domiciled in Russia, but he dies intestate and he has left some immovable property in England. So here he is a domicile of Russia, so Russia is involved, and the property is in England, so England is involved. So there is two international states involved and there is foreign element. So this is a suit with foreign element. And now the widow wants to claim share for the deceased husband's property. Now the question is, how do we classify this case? Is it a succession for the immovable property, or is it a matrimonial right? So the land is at England and the widow is moving to the English court. So according to the English law, if it is classified as a succession, then the lex situs is to be considered. Lex situs is the law of the land where the immovable property is situated. So if it is classified under the category of succession rights, then lex situs is to be applied. Whereas if it is classified under the matrimonial right, lex domicilia, that is the domicile of the deceased husband, that is Russia, and Russian law will be applied. So that is what the significance of classification of cause of action lies. And here this ambiguity, this conflict that is called the conflict of classification, and the question is which law governs classification. So here, as we have discussed earlier, the Indian law follows the private international of England for private international law. That is similar to tort. For tort also we don't have a separate statute, we follow the English common law. Same way for private international cases we follow the private international laws of England. And there have been many statutory amendments in private international law of England. Those statutory provisions have not yet been implemented or practiced in Indian law. It might be practiced in future if the need arises, but not as of now. Now that is with conflict of classification of law, and the important case law here with respect to conflict of classification of cause of action is Maltese marriage case. Once again, Maltese marriage case. So what happened here was the husband was of the plaintiff is in this case was a widow who brought an action for a share of her deceased husband's landed property before a French court. The property was situated in France. At the time of the marriage, the husband and wife were domiciled at Malta. So husband and wife was domiciled in Malta, and when the husband died, the wife came for the property, but the property was situated in France. So here, so in this case, even if it is by the French law or the Maltese law, in both states, if it was a category, the course of action comes under the succession right, that will be governed by lex situs, that is the French law. But here in this case, there was a conflict on the classification. By French law, this was a categorized as succession case, and by Maltese law it was categorized as a matrimonial case. And with respect to matrimonial case, lex domicilia, that is the Maltese law is to be applied. So here the French court accepted the Maltese interpretation of or the classification of the cause of action, and it was classified as a matrimonial case, and Maltese law, that is the law domicilia of the deceased, was applied. Now this is not a scenario in all situations or for all countries. We have already discussed that every nation has its own private international law, and that is not same to the other one. So as we said earlier, India follows the private international law of England. So if this case was to be brought in front of an English court, the English church will classify the cause of action by applying English law alone. So here, with respect to classification, or the English court will always go with the English law and no other law. So that is the importance here, and India is following the English law. And the next stage is the selection of the lex causae, or the conflicts of connecting factors. So which law is to be which? So once we have categorized the cause of action, now we have to determine if the laws of country A or laws of country B is to be applied, and this depends on the connecting factors. Now here also there can be conflicts, that is, one state A may consider certain circumstances or certain evidence as connecting factors, whereas state B might not give much importance to these factors and may consider another set of statements and facts as important. So there is a conflict of connecting factors. The choice of law rule will depend on some connecting factors such as domicile, situation of the property, place of celebration of marriage, etc. Now the decisive connecting factor may not be the same in all systems of the private international law. That is because every country has its own private international law and not the same. Even when the connecting factor is the same, the meaning given to the connecting factor may be different in two legal systems. Now English and French conceptions of domicile are diametrically opposite, and this is the perfect example for saying that the same connecting factors may mean different for the two different systems. That is, If by the English law, the domicile is, according to the English law, if the domicile of a person is state A, then by, for example, French law, the domicile may be state B, but the connecting factors are the same, but the interpretation and the result is different. So when such a conflict arises, it is necessary to decide which of the differing conception about the connecting factor should be accepted. So India follows English private international law, and by the English law, the English judge looks exclusively to the meaning given by English law, and the interpretation given by the lex fori prevails. So when we are discussing more about the procedural rules, with respect to English law, the procedural rule is always lex fori. Although the relevant foreign law is selected and applied, it does not mean that all questions arising for a decision are exclusively determined by lex causae. With respect to a suit with foreign element, there are certain areas where the lex causae is paramount, but there may be other areas where lex causae has no application, and procedural law is such example where lex causae has no application. Procedural rule is outside the control of lex causae. Procedural rule is always the lex fori. Conflict between lex fori and lex causae is yet another conflict that we have to face. Here, how conflict occurs is some state A may consider some set of rules or provisions as procedural, whereas state B considers the same set as substantive. So there arises a conflict whether this is a procedural law or a substantive law. So that is the conflict between lex fori and lex causae here. So if it is a substantive law, we have to use lex causae, and if it is procedural law, it is lex fori. So here the conflict arises between the question that whether it is a procedural law or a substantive law. The important case law here is Ogden versus Ogden. So what happened here is a 19-year-old man, and this man was domiciled in France. He married an English woman. Later, this English woman married an Englishman, and the Englishman went to a case stating that the English woman was already married at the time of marriage, and thus the second marriage is void. So when this was brought in front of the English court, so the procedural rule is always the English law, because English court procedural rule is always the lex fori, and it was brought in front of English court, so the procedural rule is English law. And here the question between in front of the court was, if the first marriage, that is the the person who was domiciled in France and he was 19-year-old, by French law he had to get the parental consent, but the marriage took place in England. So if this marriage is valid, the second marriage is void. If the first marriage is void, the second marriage is valid. So the question before the English court was whether the marriage between the French domiciled man and the English woman valid. So the procedural rule applied was the English law, and the with the lex celebrationis, that is the marriage took place in England. So they checked if the man and the woman had capacity to marry, means if the marriage was valid by English law, and the court held that the first marriage was valid, that is the 19-year-old Frenchman marrying English woman is valid. So the second marriage was void. That was held by the English court. But the question here was, here the place of marriage is England, so the marriage was held valid by England law. But there was a conflict that the requirement of parental consent is this English court saw this as a procedural requirement and not substantive to the marriage, but the French court states this as a substantive law to the marriage, saying that it determines the capacity of a person to marriage and it is substantive to the marriage. So this is a situation where there is a conflict of lex causae and lex fori. That is here the conflict arises because a single thing, that is that the parental consent. English court saw it as a procedural rule and French court sees it as a substantive law. So this is conflict between procedural law and substantive law, that is conflict between lex fori and lex causae. And then we have application of lex causae. So as discussed, we have Renvoi and Doctrine of Renvoi here, and under Doctrine of Renvoi we have simple Renvoi and double Renvoi. Now once the lex causae is decided, we would think it is very easy to implement this lex causae, but it is not that easy, because the foreign law has to be proved by expert testimony before the court, and experts and textbooks may give conflicting views regarding the actual state of the foreign law. That is, we know that we study theory in books, but when it comes to practice, there is a lot of factors that affects the practice. So what we study in the textbook, the textual knowledge and the practical knowledge is completely different. So there is a conflict between this knowledge. And now the application of lex causae brings about the doctrine of Renvoi. Renvoi arises because the different interpretations that can give to the lex causae of the chosen law. Now Renvoi means refer back or remit or remission. We have remission as well as transmission. Renvoi means refer back. So to understand Renvoi, let's consider a situation, that is a person that who is domiciled in England having land in India, and a dispute arises with this land in India. So by English law, for immovable property they apply lex situs. So the English court will apply the lex situs in the land is located in India, so they will apply the Indian law, to be precise, India's private international law. And by India's private international law, it refers to the domiciliary law domicilia. So it is again referred back to the English law. So what we see here is the English court applying lex situs go to the Indian law. Then by applying Indian private international law, it comes back to British English law. So this process is called as Renvoi, and this is a simple Renvoi. Here only two states are included. Suppose if more than two states are there, then it becomes transmission. For example, the English court refers to the there is three states A, B, C. So the forum state is A. The forum court A refers to the private international law of B, and by applying the private international law of B, it refers to the private international law of C. This is transmission. There are more than two, at least three states involved in it. Now, Renvoi is the process by which private international law of one country and private international of another country, a Renvoi is the process by which private international law of one country is applied or used by the private international law of another country. Two countries are involved, and private international law of first country refer it to the private international law of the second country, and the second country back to the first. Then the ordinary law of the once it comes back, the ordinary law of the first country is applied. And why is that? If it keeps applying private international law even when it comes back, what happens? This becomes a unending loop. So in the previous example, the English court applying lex situs go to the refer to the Indian private international law. By Indian private international law, it states lex domicilia, so it is referred back to the British. Now if they are to again apply private international law of England, then it will be again referred back to India. That is not done here. Once it comes back to the English court, here the ordinary law of English court is applied. So this is Renvoi, and this is Renvoi by transmission. And then we have Fargo's case. Fargo is a citizen of Barbaria and domiciled in France. Fargo died in France without declaring anyone as a successor. His legal heir wanted to claim property, and case was filed at France. French court found that law applicable is that of citizenship and thus was sent to barbarian law. But by barbarian law, it referred to the lex domicilia and thus the French court applied French means the case was referred back to the French law and apply the French law. So in Renvoi we have transmission and remission. Transmission, only 2 states are involved, and remission, more than 2 states are involved. Renvoi means refer back or reference back. Renvoi is a concept by which public international law of one country refers the case to another country, and the second country refers it back to the first country or any other country. Now, Renvoi is of 2 types, Renvoi by transmission and Renvoi by remission. In Renvoi by transmission, only 2 countries are involved, and the public international law of the first country refers it to the public international of second country, and second country back to the first. And what happens in remission? There is a third state involved. So that is with Renvoi. And then we have an important case, that is Re Annesley. So in Re Annesley, she was a French domiciled lady of British citizenship. So she created a will, and this will was invalid by French law and valid by English law. Case was filed at England. English court made imaginary journey to French public international law, and by French law to be applied is that of the citizenship, and this lady is a British citizenship. So the English court tried to refer it to the so it was reverted back to the English court. Now English court tried to refer to French law again by using double renvoi. So when we use double renvoi, the English court tried to implement the English court's public international law again. So but the French law did not accept double renvoi. They did not accept double renvoi, and thus the English law was applicable. Now the French law does not consider validity of a will at the first instances, as public international law does not discuss about will. Now there is another case here, that is Re Rose, and here Rose was an English citizen and Italian domicile. So Rose was a lady and domiciled in Italy. She left a will with no property to her only son. So this will was invalid by Italian law and valid by English law. English court made an imaginary journey to Italy. Italy does not recognize renvoi. Thus, English law was applied. So that is with renvoi and double renvoi and general principles of private international law. That is the various stages in a suit containing foreign element. Thank you everyone for listening. Like, comment and subscribe. Click that bell icon so that you get an update when I upload my next video or a podcast.